Are you going to say something first, or am I?
I will introduce myself and you. Right now it's letting everybody in, and so it's just kind of watching the number up as people are coming in.
Oh, yeah.
So as everybody's coming in, we're just waiting for everyone to be let in before we get started. Just probably a few more seconds and we'll be able to get started.
Okay.
Thanks, Caroline. Okay, let's go ahead and get started. I'm Christy Park. If you don't know me, I'm the new program coordinator at Access to Justice. I know everybody's used to seeing Jordan, but you'll be seeing me a little bit more now. And today we have Hannah Rowe here to do our presentation on guardianships. And just a little about Hannah. She graduated from the University of Arkansas School of Law and was admitted to practice in Arkansas in 2012. Her interest in social justice reform led her to embark on a career in public interest law with Legal Aid of Arkansas, focused on representation of clients in legal matters involving domestic abuse and sexual violence. In September 2018, she took her current role of supervising attorney for the Medical Legal Partnership at Arkansas Children's Hospital and affiliates, where she provides and oversees legal representation in a variety of civil practice areas addressing the health harming legal needs of patients and patient families. So I will go ahead and turn over to Hannah to start her presentation on Arkansas Guardianships from A to Z.
Thank you so much, Christy. I'm sorry it took me a minute on that mute button there. So first, just thank you so much for having me. And big shout out to everybody at Arkansas Access to Justice, but especially Jordan Bates-Rogers, the new director, woohoo, and Christy Park, the program services coordinator. They've both put a lot into getting these CLEs together for everyone, and we all really appreciate it and everything else that they do. I am going to, bear with me, I'm going to share my screen here, and we will go ahead and get started. All right. And going to view our slideshow here. Okay. I'm going to go through some of this kind of quickly because we have some case law updates and statutory updates that I definitely want to make sure we get. We have time to discuss at the end. And also, if you have any questions, if I very much welcome questions. If you'll put them in the chat, you can either direct message them to me or Christy if you're shy or want to be anonymous, or you can just put them in for everybody. And then I'm going to go through as many of those at the end as well as possible. So, and just getting started, my name is Hannah Rum, the supervising attorney for the medical legal partnership between Legal Aid and Arkansas Children's and its affiliates. And what we do is like Christy was saying, we look out for and we represent patients and their families in health harming legal, civil legal needs areas. And so that can range all across the board. This is just an example, some of the different types of law that we handle, some of the different areas that we can provide assistance in, a representation. And it's all over the board, because what we know is that protecting a child's well-being and looking out for their health, and not just children, but individuals in general. I mean, they have different numbers for this, but it's like something like 70% of what affects your health happens outside of a hospital or clinical setting. It's where you live. It's where you work. It is your school environment, that sort of thing. So this is just an example of different areas. And of course, I have highlighted here the minor and adult guardianships, because that is what we are going to be talking about today. Okay, so you know a little bit about me and what I do. And so now I would like to know a little bit more about y'all. And Christy is going to launch our first poll here, asking about your experience with guardianships and how familiar you are with the process. And Christy, if I need to stop sharing my screen, oh, there it is. Never mind. Perfect. And so while y'all are taking this poll, just about how much experience you have with guardianships already, I'm also going to use this opportunity to put a plug in for volunteer attorneys with our program. It can be in any area of the law. It doesn't have to be a guardianship. You can be as specific as to how, complex of a case you'd like it to be. If you want it to be a straightforward, uncontested, to what counties you would be willing to handle a case in, to I never want more than one case a year. We welcome any and all help. And I can tell you the feedback that I've gotten from our other attorneys that volunteer a little bit of time each year to help represent some of these patients and patient families, have found it to be a very gratifying experience. And so at the end of the presentation, well, I don't want to make promises I can't keep, but the end of this week, beginning of next week, you're going to get a packet with everything from the presentation today, updated slides, the new laws we're going to talk about. And I'm going to include in that a form for you to fill out in the event that you would like to volunteer with us. And like I said, you can be as specific as you want, or of course, contact us if you have any other questions.
Okay, it looks like our results are in, and it's pretty varied. About 20% said, Barry, I work in the legal field and I'm involved in guardianships regularly. About 40% said, somewhat, I work in the legal field and have been involved in a few guardianship cases. 13% said, not at all, I work in the legal field, but I've never handled or assisted in a guardianship case. Just 2%, Barry, I do not work in the legal field, but have a good bit of experience and knowledge about guardianships. And about 20% said, somewhat, I know a little about them and or have some personal experience. We had 0 on the what is guardianship, so that's good.
Okay, so that's good to know. We all have at least a foundation here that we are starting with, and that helps me to tailor some of the information that I'm going to give you all today. Okay, so Just want to start off with a few important statutes, and I apologize for having just a regular, boring old PowerPoint presentation, but I think that sometimes when we're going back and looking for this information, what was it she said about this? This can actually be very helpful. And so these are some of the statutes that you would look to just from the very beginning. The definition statute, which is the last one I've listed here, very important statute. Most titles have definition statutes in them, and they're amazing. I think we forget about them because they're not usually with the meat of the laws, which is where we're automatically going to. Very helpful, though. Also, in talking about, what venue is going to be appropriate. Typically, it's going to be where the person over whom the guardianship is being sought lives. And of course, what the purpose is of a guardianship. Guardianship should be the least restrictive alternative. If there is any other way of accomplishing the objectives that's needed, you want to go any other route, and you have to go any other route before you go the guardianship route, just because guardianships do involve the removal of some rights, and that's a big deal. Okay, so what I have done is I have provided a guardianship flowchart. I tried to make it as simple as I could, but I'm just going to walk through it as quickly as I can so that you all know how it operates. But then at the end, there's a website that I'm going to give you as well where you can access this. And there's actually a 20-minute video that goes with it that walks through it. And so if you need a refresher, you can use that. So we're starting off just, is the petitioner over the age of 18? You got to be 18 or older to get a guardianship over somebody. Are you an Arkansas resident? Are you of sound mind? Are you an unpardoned, convicted felon? Okay. Used to be, up until I believe it was July of last year, there was just a bright line rule saying if you've ever had a felony and you haven't been pardoned, then doesn't matter if it's been sealed or anything, you cannot be a guardian. And people thought, that's crazy. We don't even have that high of standards for, if you're going to adopt or something. And sometimes child has an elderly parent that they need to get a guardianship over, and an arrest from 1989 conviction shouldn't keep them from being able to do that. So they did remedy that issue. However, now, if you have a client that wants to become a guardian, but they do have a felony on their record, you've got to get certified copies of their sentencing order, and then submit those to the judge. And then the judge can decide whether or not he's going to allow the petition to move forward. There's also going to be information about how to access all these different forms at the end of the presentation. So I'm not going to take time to go through this, but this is literally the ACIC, the Arkansas Criminal Index something or other. But it's the form that you fill out to obtain a background check, so that if you need to find out if there actually is a felony on the record, and then if there is, you need to go to the courts where they got that, where they had that conviction, and get those certified copies for the judge. So if we have met all of these requirements, we get to keep going. So we're going to go to Section A. And Section A is about the proposed ward, or you'll see AIP, meaning alleged incapacitated person. For purposes of this presentation, I use the terms ward or proposed ward for minors, and then incapacitated persons or alleged incapacitated persons for adults. You're going to hear them used interchangeably and differently. There really isn't just a consistent consensus on how those should be used. And this new law we're going to talk about later makes it even more confusing. But for purposes of this presentation, that's how you know if we're talking about a minor guardianship or an adult guardianship. And so if the person over whom the guardianship is being sought is under the age of 18, then we know we're going to need to get a minor guardianship. If they are over the age of 18, then we are going to go through a different analysis. And as we go through each one, it'll take you to either section B or section C. So we're going to start with, yes, they're under the age of 18. Then we're going to look at whether or not they've been emancipated or married. Typically, you're not going to come across that issue, but it's good to know that is a bright line rule there. They must be unemancipated and unmarried. And if they are unemancipated and unmarried, then you are going to continue your analysis to section B, and obtaining a minor guardianship. Now, if they're over the age of 18, is the alleged incapacitated person with a disability that is so substantial that they can't make or communicate decisions to meet just basic essential requirements for health and safety? And if the answer to that is yes, you're going to continue to section C and skip over section B. And section C is going to go through a petition for guardianship of an incapacitated person, an adult guardianship. If either one of these, the answer is no, guardianship's not going to be appropriate. You may want to look into some alternatives such as a power of attorney. So we continue as though we are seeking a minor guardianship. And then you're going to look at all the different requirements, the different there's lots of information that the statute sets out that needs to be included in the petition. And you have additional statutes that list out the people that have to be notified of these proceedings. You have to look at whether or not the minor is older than 14. Now, again, the new law we're going to talk about, it's going to be 15 years and older. But if they are, they have to be personally served with the petition, a notice of hearing, statement of rights, and we're going to get into some of that in a little bit more detail. But it's all laid out in these statutes and in the forms. And then finally, you want to look at, do you have any affidavits of consent? If the parents are consenting, mom, maybe mom's not in the picture and dad is being deployed or incarcerated, or just needs to work on some stuff and wants grandma to be able to raise child. Many different situations you can get an affidavit of consent. You don't have to have them though, okay? They're not required or anything, but it can just be helpful, and it's helpful as an extra way of letting the court know that everybody's on board with the guardianship. So also one other side note here with regards to notice. So notice has to be provided at least 20 days before the hearing, and I have here via summons or probate notice, and this is because we handle cases in all 75 counties. I have not been in all 75 counties. I've been in probably at least 50. And they are very different in lots of things. I always recommend, if this is a new county for you, reach out to the probate clerk, the judges, trial court administrator, and ask them how they like to do things. What's their preference? This is not you're not attempting ex parte communications. You're just finding out, do they want you to use a summons or a probate notice? They may have a very specific form. There are letters of guardianship that get issued at the end that some counties, they force you you must draft them for them. And then there's some counties that are like, no, you can't draft that, we draft that. So it's good to just get familiar with your area. So if you've met the requirements in the petition, you've properly served the persons entitled to notice, then you're going to go ahead and continue to section D. We're going to go back. So section D is then you've gotten your hearing date, you've gone to court, did the court award a guardianship of the person? So now we're going to backtrack and we're going to pretend like right here, we said, no, they're not under the age of 18. They're over the age of 18, okay? So then we look at, are they totally incapacitated to the point that they cannot look after their own well-being, health, safety, the basics. Then if you can answer that yes, you're going to need to petition for guardianship of an adult incapacitated person. So we're skipping the minor section, and we are now at section C for an adult guardianship. Same thing. Does the petition meet the requirements that are set out by the statute? A lot of this is information such as whether or not the petitioner, the person that wants to become the guardian, is already the guardian of somebody else. If they're the guardian of 5 or more people, they have to notify a whole different slew of individuals, namely DHS. Then there needs to be notice of that to other agencies. They want to know the age, date of birth, current address, sex, etc., of the alleged incapacitated person. They need to know the relationship between the alleged incapacitated person and the person that's seeking guardianship. You're going to need to state whether you are pursuing a guardianship just over the person or a guardianship over their estate, or both. And also who the next closest relative, blood relative is. And if you've provided them with notice. So it goes on again to, has the notice of hearing and statement of rights been personally delivered to the alleged incapacitated person? Or of course, in a minor guardianship case, if they're 15 or older, to them as well. And do you have any affidavits of consent? Do you have a sibling? You need to get guardianship over your father who has Alzheimer's. Do you have a sibling? Well, your sibling should probably file, you should try to get an affidavit of consent signed and notarized, and be able to file that as well if you can. And then finally, and this is a big, big one, do you have included with your petition as an exhibit an affidavit of professional evaluation? And this is super important. And we will talk about this more in the case law update portion. But again, going back to how amazing the definition statutes are, if you go to the definition statute, it's like 2865-101. It'll tell you what's a licensed professional for these purposes. Typically a doctor, but could also be licensed psychologist, licensed social worker. And what information needs to be included. And it's very specific. They have to have done an evaluation within the previous 6 months. They have to talk about physical capabilities or disabilities, intellectual capabilities, disabilities, adaptive behavior, and then make recommendations as to whether or not a guardianship is needed. And if so, how broad does that guardianship need to be, or how limited can it be? Excuse me. And so you're going to get that. You're going to attach that to your petition as your exhibit A, and then you can move forward. Okay. So either way, if you have either gone the route of a minor guardianship, of obtaining a minor guardianship, or gone the route of obtaining a guardianship over an incapacitated adult, then you're going to go through the Section D analysis. Did the court award a guardianship of the person? Did they give it to you? You went to the hearing, and did the court agree that there needs to be a guardian? Okay, so if the answer is no, oh no, what went wrong? We need to look at some alternative options. You may find that you missed something in terms of the requirements set out in the notice statute, or that they found that the affidavit of professional evaluation was insufficient. So maybe you just need to correct and amend your pleadings. But if they outright did not agree that the guardianship needed to be awarded, then you need to look at possible other remedies or ways of meeting the objectives of your client. So after that, has an order of guardianship been filed and has the petitioner signed an acceptance of appointment? You'll see this in the forms list at the end. And then, so your order, typically we draft the orders, of course, and then submit them to the judges. The judge will sign the order. It'll get filed, and your client's going to sign a statement that they are accepting the appointment, and that will be filed. And then we have the letters of guardianship. And essentially what these are is these are letters issued from the clerk, from the probate clerk in that county, because that is where you're going to handle your guardianship cases, is in probate, putting others on notice that there is in fact a guardianship in place. So for example, if it's a minor guardianship, you would want to give a copy of the letters of guardianship to the school or to daycare. If it's an adult, then you want all their medical providers to have copies, that sort of thing. It's a way of letting them know without showing them the actual, without having to give them the full-blown order. And then does the petitioner, now the guardian, understand and is able to file an annual report? So an annual report, it's like a 2-page max form that is basically, you're just filling it out every year to let the court know how this person, the ward or the incapacitated person, how they're doing in your care, and if the guardianship is still needed. And you file it around the anniversary date of the award of the guardianship. And you do that every year. That is never going to be waived. There are bonds, accounting of inventory and estate and notice thereof. These are some additional, when you have when your client is obtaining a guardianship over the estate of somebody that has real property, then you're going to, and I'm sorry, I have to move this little toolbar out of my way. Okay, then you're going to have to look at these other forms as well. But preparing an annual report, you're always going to have to do that. And so a lot of courts will just leave the case. Like, for example, if you go to look at it on eFlex or Court Connect or something, it'll be left as open set for review so that they're not having to reopen it every time they go to file it. Some close it and make them pay $50 every year. And that is a question that I am in the process of searching for the answer to, that no one has been able to clarify for me. And I have not been able to find any clarification on whether there should be a specific procedure followed there. So, okay. So at this point, we are going to move on to section E. Can y'all, Christy, can you see my toolbar, my Zoom toolbar that I'm moving around?
No, we just.
Or do you just see?
Yeah, we just see that you and the actual handout. There is a question about if you want to, about a possible typo on the first page, if you want that now, or we can get to it later.
Yeah, so I did actually see that, and it's just worded really quite funnily. So let's see, where are we at here? Right here. Are they unpardoned? Oh, no, that is a full-blown typo. I am so sorry. It's the wording in the statute using those terms, an unpardoned convicted felon. I always get that backward. So yes, whoever asked that question, Mr. or Ms. Anonymous Attendee, thank you for pointing that out, because they are backward. If they are an unpardoned convicted felon, this should be yes, and then we go to have you obtain the certified copy. Yes, thank you so much. And I'm amazed that you are the first. Nobody else has pointed that out. Okay, thank you. All right. And so here we are. Okay, section E. So this is, did the court enter an order of guardianship of the person and the estate? could just be or just of the estate. But for purposes of this presentation and for what we do at our firm, we're typically talking about guardianships of the person. So, okay, did the court set a bond? Bonds are very weird, and I don't want to go down a rabbit hole with them, but bonds are given to ensure to keep a guardian honest, if you will. So the guardian would then go obtain a bond from like a surety company or an insurance agency. And that way, if claims were filed against the guardian that they were acting unethically, unprofessionally, not fulfilling their duties as guardian, then they would be responsible for paying the remainder of the bond. And that would go to, the bond would pay out to the incapacitated person or ward's estate. If you just get a guardianship of the person, then the court can just dispense of the bond altogether, or they can assign a bond, but not to exceed $1,000. I kind of, as a standard, of course, keeping in mind I work for nonprofit, as a standard, like to just go ahead and include provisions in my petition about asking the court to waive the requirement of bond. And the way that the statute reads, I think it pretty clearly reads that if you're getting a guardianship over the estate, there's supposed to be some type of bond. It does have exceptions for if their estate is, if it's a totally cash estate, they can dispense with the requirement of bond so long as they deposit it into like an FDIC account. But I have also had judges that have said, no bonds required, even if it was a guardianship over the person and the estate. So, but as a general rule, if it's an estate, a guardianship over the estate, if there's anything more than just, a little bit of money there, then the judge should probably assign a guardian's bond. But there could be, you could get a guardian's bond for it might be $100,000. And I was reading one case but I guess because the person had a perfect credit record or something, they only actually had to pay like $400. Now, that's assuming that they are 100% loyal and fulfill all their ethical obligations and duties as the guardian. So, okay. There is also, let me say one more thing about that. When you're dealing with children, and a lot of times with adults, their estate may not be anything more than their personal property. That's not what we're talking about in terms of an estate. Or they may just receive some sort of Social Security or SSDI. That also doesn't have to fall into this category of an estate because also SSA requires an annual accounting already of whoever the representative payee is. And so that's something else that I will include. And when you can look at these example petitions later, you will see as another argument as to why they should waive, the bond, because they don't have anything other than personal property and Social Security. And then also this inventory of estates and accounting and notice of filing accounts, because the only thing there is to account is the Social Security, and Social Security already has that requirement set in place. And so that's essentially this, and it does get deeper, and there are some more crevices. This is why doing a flow chart for a guardianship was a lot harder than it seemed like it should be right off the bat, because there are so many if this, then this, different paths that you could go down. But let me make sure I'm not forgetting anything else about the bond information. And yeah, I mean, there's just some extra stuff to know is in the how they calculate it. They default to the just personal representatives bond requirements of amount, with the exception of that real property shouldn't actually count as income and be considered for purposes of the accounting, because it's not expected to pass through the hands of the guardian. So they're just looking out for it. Like I said, it gets kind of, it gets deeper, but okay, I've got a question here. I am going to come back to that in just a minute. So, okay, congratulations, your guardianship is complete. These little asterisks are just in reference to throughout the flow chart, who, you know, who the AIP is versus the proposed board, etc. Okay, so some additional statutes that are just really good to be aware of. Emergency temporary guardianship. When you need like to get an ex parte order, you need a judge to sign an order giving a guardianship immediately. You don't have time to go through, you know, jump through all the hoops. And we're going to talk more about that because that's a big portion of the law, the new law that's coming up. So we're going to talk about that some more. So successor guardians, standby guardians, this also kind of goes to in a living will or last will and testament, you can name who your preferred guardian would be in the event that you should become incapacitated, and or your preferred guardian of your children in the event that you should become incapacitated. And courts are gonna give like they're going to give preference to your wishes, but they still have to decide that they are appropriate or that they meet, you know, the requirements to be able to step into that role. And then guardianship termination, and we're going to talk about that more here with the case law updates that we're going to get to. Okay, so my next poll, time for like a fun moment. Christy, if you want to go ahead and share the second poll. There are a lot more celebrities and folks we would not expect to have been wards at some point in their life. And you tell me who.
It keeps looking like the votes are in, then it starts moving again. Okay, looks like we have most of the votes in. And so we've got 45% for Britney Spears, 1% for Eric Clapton, 5%, 6% for Marilyn Monroe, and 1% Joni Mitchell, and 45 said all of the above, and 1% said none of the above.
Okay. The answer is all of the above. So I have to share, I mean, some of these are very, very surprising for me as well. I think that Britney Spears is the most famous. I would say Britney Spears and Amanda Bynes are two of the more famous people that have been in the news. But it is also true that Marilyn Monroe, a family friend, got legal guardianship of her when she was 16 to get her out of foster care. Eric Clapton grew up thinking his sister or his mother was his sister, and actually she was his mother, and his grandparents were not his parents. They were his grandparents with legal guardianship over him. I do not, this is not an updated Free Britney post here, but just another example. And like I said, the one that's probably the most known. I also, with Joni Mitchell, she suffered a brain aneurysm later in life. And because that brain aneurysm, someone had to get a limited guardianship over her to be able to make medical decisions for her for a period of time. There were some others, Brian Wilson from the Beach Boys. First name, I don't remember, Reisner from the Eagles. Several people. So a lot had situations of it was when they were minors. But Casey Kasem was another famous person who there was a lot of press on allegations that the guardianship that I believe it was his daughter over him had been badly abused. He'd been taken advantage of, and same with Mickey Rooney. All right, so moving on, we're going to talk about co-guardianships. Y'all, fingers crossed you get to see and hear this video, because if so, it'll be the first time I've successfully done it in a presentation. Christy, after I hit play, you just give me a thumbs up or a thumbs down.
Now, you must have many questions.
Well, Sophie, I mean, I think that's who we're both thinking of.
Yes.
What will happen to her now?
Allison and Peter talked to you about their guardianship arrangements?
No.
Well, in preparing their will, we talked about who would take care of Sophie in the unlikely event that they should both die, and they named you. Both of you.
I'm sorry. They picked us together?
I'm sure this isn't exactly how you wanted to start a family.
There's been a misunderstanding.
Yeah.
We are not married.
No. They tried to set us up in a blind date. We never even made it to the restaurant.
I don't even know if you
He's
call
not
it a
exactly
date. I
my
mean, he
type.
was such a...
Okay. So the takeaway from that is not in Arkansas. Okay, in Arkansas, co-guardians need to be married. So you're not going to run into this particular situation, although it does make for great romantic comedy fodder. So let me look at some of these questions. Okay. For somebody that needs a guardian, I see a question about that needs a guardian, is in assisted living and has income. They would probably need, and they don't have a family member who could do it, or a good friend. They may be in need of a public guardian. And so you can reach out to Disability Rights for more information on that. And then there are also firms that it's part of what they do, some estate planning firms. And so a public guardian is what I would look into in that situation. Another question about their own personal specific case. I would, needing to file for custody over a disabled child before they turn 18, I would recommend that you call our helpline, and I can provide that number for you. I don't know it. It's 1-800. I should know it off the top of my head, and I do not. But I can provide that number for you, or if you Google Legal Aid of Arkansas, you will get that phone number. Call and do an intake to discuss with a family law attorney your particular situation.
I can put that in
sorry.
I'm sorry. I said I'll put that in the chat for everyone. The phone number.
Oh, that'd be great. Our helpline number. Yes, that would be awesome. And then another question about whether a judge can refuse to issue an order because of one or more parents residing outside of the United States. No, I I don't know how, and I've certainly obtained guardianships for children whose parents lived outside the United States on multiple occasions. And you are correct that there is a provision under 2865-207 that states that outside of the contiguous United States, which I find very weird because I'm like, what about Hawaii? What about Alaska? But it says that they don't have to be served. Whether or not they can consider evidence because it occurred outside the US, a judge has a lot of leeway and discretion in what evidence they're going to hear. Typically in a minor guardianship case, as in any child-centered case, they're going to listen to that which they need to be able to listen to determine what's going to be best for the child. So that may be something to either discuss further, or you might reach out to Arkansas Immigration Defense, another nonprofit firm. Stephen Coker runs that, and he's amazing with any immigration issues. And so he may be able to provide additional insight. I haven't seen that happen, but judges do what they want to do. All right, so we're going to move on.
Hey, Hannah, there was one more question that was in the chat, and it's actually from Stephen Covert, speaking of him. And I'll, if you want, I can read it to you, and if you want to answer it now, you can, or move on if that's okay with you. I need to get an emergency guardianship, then permanent, for an unaccompanied immigrant child. Uncle lives in Iowa and wants to petition for guardianship. Can it be done? Child resides in Arkansas.
Okay, so the child lives in Arkansas. The person that needs to get the guardianship is in Iowa.
Yes.
Okay, so yes and no. Both. And I love that I totally gave you a shout out and told people to contact you, and you were listening. So yeah, hi, Stephen. So there shouldn't be an issue with, there should not be an issue with venue if it's filed in Arkansas, because there is actually a very specific provision in the statute that is called it is like special nature provisions, compensations, discretionary. Okay, well, somewhere it may just specifically be in the venue provision. I would have to double check. I've had this issue before, and it basically states that when this happens, they can file, you got to file where the kid lives, mainly because of the UCC JEA, the Uniform Child Custody Jurisdiction Enforcement Act. And that says that a kid should live somewhere for 6 months, and that's where you would file. But there is a special way of getting around being able to file, despite the fact that your client maybe isn't a resident of Arkansas because of the circumstances of the case. And I'll email you that statute later, and I can send it out to everybody as well. You don't see it come up very often, but sometimes in emergency situations or like at the hospital, we see it a little bit more often. Was that all of the question, Christy, or was there another piece to it?
I think that was it. I'm looking at, yeah, he said yes, that was it. Thank you.
Okay, well, and then you will follow up after you get that guardianship, because you know you're going to get that guardianship, and the child is going to probably move to Iowa then with the uncle. You can register the guardianship there in Iowa, because in theory, we want these guardianships to be supervised or for where they live to be who has the oversight, so that they know if something wonky is going on, right? So you'll get it in Arkansas and transfer it to Iowa, most likely. Okay, so I know I've only got 10 minutes, but the good news is kind of been answering questions along the way. So, but I really want to get to these next two pieces, case law update, and then a new piece of legislation that is going to become law here pretty soon. So in re-guardianship of Helton, an incapacitated adult, what you need to know from this case from last year is that pardon my language, a half-ass affidavit of evaluation is not going to cut it, okay? The doctor, the psychologist needs to put in there everything that the statute requires. So physical condition, adaptive behavior, medical issues, intellectual functioning. So in this case, it had all that in there, but it didn't go on to say that they recommend a guardianship and that these specific areas, and in these specific areas, they're going to need assistance. So if they don't put that, if they don't put everything in there that statute is asking for, it can get thrown out, or it can get thrown out on appeal. Okay. This is a really, really hot topic with child or minor guardianships. And this is the case that I have parsed out, although there's been another one before it and several, or another one since and several before it that all kind of fall in this line. But it's a question of whether or not when parents consent to somebody having guardianship over their minor child, what are the ramifications for that when later down the road they want to terminate it? And this is really important. This case went into the fact that, if the parent has not been found unfit explicitly, if the court has not had a hearing and determined mom's unfit, then whenever she comes back to petition to terminate the guardianship, she doesn't have to overcome that. Basically, she is still assumed to be a fit parent at that point, right? But so this says that going on to determine what's in the best interest of the child is inappropriate because she hasn't been found to be unfit first. And there are major constitutional due process interests in being able to raise your own child. Now, this should not be taken to say that then a guardian, so say mom consents to a guardianship for her grandpa to take care of her little boy, because, I don't know, maybe mom has a substance use disorder. And she receives treatment for that. And she comes back and she wants to terminate the guardianship. At the outset, the presumption is that it should be terminated because she consented. She was never found to be unfit. That should be the end of it. But the guardian can still raise the issue of unfitness at that time and then just bears the burden of establishing that they're not fit. So it doesn't, you're doing down the road what you could potentially do more easily from the very beginning. So maybe, grandpa says, well, but unfortunately, she also suffers from X and X and Y and Z mental illnesses, and I don't believe that she's fit. So that can still be hashed out in court. But at the outset of it, she is presumed to be a fit parent, and the guardian has the burden of establishing that she is not at that time. Okay, here are other cases on this issue, and the most, so really that Morris v. Clark, it is just another more evolving or another evolution of like the minor guardianship of EMR, and then kind of one of the big daddies, the Supreme Court case from 2000 is that Troxel v. Granville. And so that one is the Supreme Court saying, you know, that parents have constitutional right to raise their own children without the government's interference. And so, you know, they should be afforded those rights. Then Henson v. Brumble, which came out really recently. This just took the fit parent presumption to a whole nother level in saying, hey, guess what? A de facto finding is not good enough. So even if in the order it says that mom is going to prison for 20 years and dad has admitted to having and dad is a sex offender, I don't know, that these children need this guardianship, and it is in the best interest of these children to have this guardianship. They didn't use the words unfit. So Henson v. Brumble is taking it takes it to that level of, you can't imply that they've decided that they're unfit based off anything else that they've said. They must say unfit. Who knows? That may end up, I would not be surprised at all. There have been so many cases in this arena, wouldn't be surprised at all if that didn't come back around, you know, and get modified some more. But that is where we are right now. It must say unfit. Otherwise, down the road, if parent wants to terminate, you're going to bear the burden of proving that they are unfit then in order to maintain the guardianship. And I'm running out of time. So, okay. This is an example of some of the different documents that you're going to potentially need and use in handling guardianship cases. Now, if you click on these guardianship forms from here, it will not work. It is going to trigger you to request to share my drive. And my firm has, you know, walls to where we can't share with outside the firm. And what I will do is I will respond with an email directing you to the website that I'm going to give you right now. All of this, okay, all of these are on the Arkansas Courts website. You can click on that, but it's also right here. All of those forms, they're just not necessarily as pretty and formatted, you know, but also if you go to this website, arlegalservices.org/guardianship scroll, you can see the scroll. You can watch the 20-minute walkthrough of it. Most of those forms in my format are on there, but if you're missing something, then you go to this website. Okay, sorry. So these are where you're going to get this is the most up to date. Okay, and in the last 2 minutes, I am going to talk about the new law. Okay. How do I make this big? Okay, this. That. Okay, are you guys seeing that bell? Yeah, okay. So this is a bill that affects 4 different provisions of the guardianship law. Namely, the first one is the rights of incapacitated persons. They're changing it to a Ward's Bill of Rights, completely repealing 2865-110, which is rights of relatives, because really that's incorporated into the other provisions that are being amended. And then 2865-213, which is hearing and effective determinations, is being renamed rights of wards and proposed wards. And then 2865-218, which was temporary guardianship, is now being called emergency and temporary guardianship, which is what I already unofficially called it. And it cleared some stuff up there. So very quickly, so this is the first one that's being amended. Okay, your Ward's Bill of Rights. There's not anything in here that is crazy outside where we already were in terms of the rights that these folks should have. I think the most confusing thing is that it says, as used in this section, ward means an adult for whom a guardian has been appointed. Well, as you will see further down in the other sections, they revert back to calling them an incapacitated person and a child award. So that's just fun. But it does make it clear that they retain all legal rights except those which have been expressly limited by court order, or those rights which have been specifically granted by court order. So here's the bit about appropriate communication and visitation, what the procedures are going to be for that if they are wanting to prohibit or limit communication. And then rights to, all their paperwork and copies of everything. I think that probably one of the most important ones to know here is that they have the right to be present. This is just the law that's been repealed. They have the right to be present, and should they not be, the court's going to want to know why, and then they're going to decide if that's good enough or not. So whoever has physical custody has got to make all reasonable efforts. I've had clients, though, that they could only be transported via ambulance. But I think that this is going to come up the most with respect to minor guardianships. Are they expected to be taken out of school? At what age? Some judges don't allow children in the courtroom, period. So we're going to see a lot develop from this section. And then going forward, another big thing that is going to change. So they are now calling it emergency and temporary guardianships, and they have gotten rid of, it used to be if you got an emergency guardianship, you only had 3 days to get a hearing on the books. Now you have 14 days. And that is good because you're required to get folks served. If you're supposed to get somebody served and you can't get them served within the 14 days before you have your temporary guardianship hearing, even after your temporary guardianship hearing, you still have to keep trying to serve those individuals. I am rushing, but long story short, there are some important changes that have been made to those 4 provisions I listed. And I'm going to send a highlighted copy of this out in that packet that I told you about. That is definitely worth looking at. However, it does not go into effect. Technically, the governor still has to sign it, but it passed by a majority in the House, or not unanimously, passed unanimously in the House. There were only 2 nays in the Senate. The governor's going to sign it, and then it will become law 90 days following sine die or the end of the legislative session. So it will become law on July 29th, 2021, barring some very unlikely circumstance. So not the law yet, but will be the law July 29th, 2021. And I went 4 minutes over. But Christy, I'm happy to still answer the remaining questions, or do you need to just cut me off?
You're welcome to answer the questions. I think the poll will launch as people exit. So if people need to get off and can't stay to answer the rest of the questions, just please be sure that you complete the survey, because Hannah would love to hear your feedback. But yeah, if you want to go ahead and answer those questions, we can keep it rolling until you get through them.
Absolutely. And I apologize. The last time I did the CLE was 2 hours, and we didn't even have all this brand new legislation. So I apologize for having to rush rush through some of this. Okay, so recommendations when one parent consents and the other parent does not. Are there any specific strategies here? This, Susan, this is a pretty common situation that we run into because maybe it's dad's mom that wants to get guardianship and dad's in prison, but mom is not in prison, but maybe is dealing with a substance use problem. And maybe taking the child to unsafe places and whatnot, and doesn't want to consent to the guardianship. Well, one thing is, I have in the past, I'll sit down and explain to them how favorable the law is to them if they consent. Like, look, you can consent. And then at any point you decide you want to revoke, if you've consented and there is no finding that, you're an unfit parent, as opposed to us going to trial and airing all the dirty laundry and stuff, and the court potentially making that declaration, you're going to have a way easier path back to where you want to be. Sometimes they either, well, I don't trust you because you're not my lawyer, and that's fine. Or, just think it's crazy and whatever, they're gonna fight it. I mean, you just try it. You get the consent from dad and you file it, and then you handle your case against mom, or vice versa. Because a lot of times it's the child of like grandparent that wants guardianship. Their child is the one that's consenting, but the other parent isn't. I see that a lot, but are you aware of any case law that shows facts in which the guardian properly overcame the presumption and established that the natural parent is not fit? So in the appellate, because usually when they have made it to the appellate level, and I've seen more to do with that not happening. But I saw Christy wants to answer live. Christy, did you have something you wanted to?
Oh, no, I'm just trying to clear them out as you're answering them so you won't have so many in front of you. That was all. You are answering it live, so I'm
sure.
answered.
So no, but I think it's just as likely as not. The difference is that usually when somebody that has had a child that somebody else has needed to obtain guardianship over, whenever they're ready to actually file to terminate that guardianship, usually they have overcome whatever obstacles they were previously facing that led to the need for the guardianship in the first place, if that makes sense. They had a substance use problem, but now they've been in treatment and recovery for a couple years. And so then they're gonna go ask for it to be terminated. And the thing is that then the guardian has to prove that they're unfit at that time. Not that they were unfit back when they got it, but that they're unfit then, which time oftentimes they're not unfit anymore. Does that make sense? Okay. How quickly can a legal aid help someone obtain emergency guardianship of a ward? In theory, it can happen very quickly. I will say that Legal Aid of Arkansas takes on so many cases, and the vast majority of them, well, not the vast majority, the majority of them do fall in the family law realm spectrum. And unfortunately, there are so many people in really dangerous situations right now that it would depend on the level of the emergency and relative to the other applications for emergency assistance that we have. But I mean, an emergency guardianship can be obtained in a week at most optimistic if everybody was doing everything with their documents immediately, both the applicant and the attorney and the judge. It could happen. It could happen very quickly. Yes. And then they would have to set a hearing usually within 3 days because the law hasn't changed to 14 yet. And everybody be hustling to get the folks that need to be served in that 3 days. Does a judge in probate court have inherent authority to investigate, call witnesses, subpoena documents? And if yes, where can I find that given authority in the family code? So I'm going to be very honest here. I don't know 100%. I do not think judges are supposed to do outside investigations or call witnesses or subpoena documents. But here's the thing, in reality, it happens because they ask questions. You call a witness up there, you ask your questions, opposing counsel asks their questions. Judge says, I got a few questions. He asks his questions. I've even had a proposed ward with me, just make it available if the judge wants to ask him some questions, and subpoenaing documents and whatnot. Here's what I see. I see a judge tell an attorney, you better FOIA or subpoena these records and have somebody here to testify about them. And that's how they subpoena documents, is they tell you that you better do it or your case is not going to work. You're not going to prevail. So that's how I see it go down. But as far as official word on that, I can't give it. I'm sorry. Okay. Can a guardian relinquish guardianship even if the ward is still incapacitated? For instance, if the guardian-ward relationship deteriorates and is no longer beneficial? Yes, but it's tougher. I have a case I'm dealing with that kind of involves this right now. And so if we don't have a suitable substitute guardian, then we would look to, well, it'd be a public guardian or someone within adult protective services or child protective services, depending on the age. And something would have to be figured out before they could just relinquish, because that's a big, when you ask to become a guardian, I mean, that's a big commitment. And I mean, it's under, in the code, it's under fiduciary relationships for a reason, because you're committing a loyalty to these people. That doesn't mean it doesn't happen that it deteriorates, but you need to, if it's best if you can have somebody ready to step in and fill those shoes, then absolutely, that can happen easily. If you don't, it's going to be a little bit trickier of a process. Okay. If a judge in juvenile orders guardianship of a minor without a petition being filed, you have to file a petition after the court order is issued. This is really interesting. So I guess you mean like in juvenile cases, like FINs or dependency neglect cases, where judges assign custody or guardianship to somebody in that DHS or FIN's case or whatever, and then they close the case. So no, you don't have to then go. So there's a family needs of services case, a FIN's case, and in it the judge says, okay, mom, she's been through too much. All this stuff's going on. Like she's going to be safer. We need to put her with grandma. So the judge orders a guardianship with grandma. Well, then that case is going to close. And say down the road, but the guardianship remains in effect. But then say down the road, mom's like, I want to terminate that guardianship. Mom is going to have to open a case, a brand new case, okay, to modify the guardianship. She's going to have to open that case in the circuit court because she cannot go back and file it in the actual FINS case or DHS case or the juvenile case. So no, you don't have to go file a subsequent petition. Your order is good, but if you want to do anything with it after the fact, or somebody else wants to file anything to do with it after the fact, then a new case has to be opened. If that's at a hearing on the merits, I'd clarify in the record. Ask that the court conform. Yeah, so I think, again, this is a good example. Yes, ask the judge to straight up say, mom is not fit. Mom is not fit to parent. Because then when it comes back up in circuit court, just what they were saying in the, what was it, the Henley Bumble case that we were talking about earlier, is that just because the judge said, no, mom's got a substance use problem, dad's incarcerated and a sex offender, and nobody knows where either one of them lives or anything like that. Yeah, that implies to us that they're unfit. But what that most recent case says is that a de facto finding of fitness isn't going to work. They're going to need to explicitly say it. And that's even in juvenile cases that may later pop up in circuit court when they need to be modified. Okay. Whew. Okay, two more. So if we take a CALS case for appointing, and that is Center for Arkansas Legal Services, for those of you still on that don't know what that means, for appointing a guardian of an incapacitated adult, is there a good willing source, such as someone at ACH or UAMS, for getting a pro bono medical? Oh, absolutely. Absolutely. There should never be, if you're taking an adult incapacitated person guardianship case, there should not be any issue getting a doctor to fill out that affidavit. If there is a problem, then that should trigger in your mind, does this person really need a guardianship, or is there possibly a less restrictive alternative? Because they're going to already be seeing a regular doctor. And so if there's any hesitation there at all, if not many regular doctors, then you may need to reevaluate your case altogether and see if guardianship is the appropriate route to go down. And then I see something here from in Pulaski County, juvenile courts will do orders for temporary custody instead of a guardianship. Yeah, and in Saline County, right next door, they do guardianship. So it just, you never, I've seen all sorts of crazy orders, y'all, from judges, and you just never know. Ultimately, you have got to adapt to your surroundings. Okay, we are 17 minutes over, but I'm so happy that y'all had so many questions. I hope I answered them, to your expectations, but please feel free to reach out with any follow-up.
And just a reminder, if you want CLE credit, you should have been emailed a form this morning. Please email that back to cle@arkansasjustice.org to receive credit. We do need those back by April 9th if you want credit. If you happen to register within the hour before the starting and didn't get that email, please just email me and I will send you the form to fill out.
Okay, thank y'all so much for having me, and reach out if you have any additional questions. I'd love to I'd love to chat. Thank you. Thank you guys for having me. I didn't see if my dog made an appearance in the background at any point or not, but he might have. All right, y'all have a good afternoon.